Justice Jackson?
So I guess maybe I just don't understand how the tests work anymore. Maybe it's post-Rahimi, I'm not sure, but it seems like you're asking us to trust Congress's legislative judgment here that unlawful drug users pose a heightened risk of misuse, but that this test really doesn't provide us a way to check that in any meaningful sense. And I guess the benefit of the pre-Bruin kind of means in scrutiny is that you've got to the bottom of whether what Congress was actually doing here was legitimate and whether the means that they had chosen, the disarmament of this person, was tailored, sufficiently tailored to that aim. And what's worrying me is that the current Bruin test, modified by Rahimi or whatnot, is not allowing us to assess that. And that's really the problem in this situation, that the concerns, the questions that you're being asked seem to all relate to people's concern that even if we all agree that Congress can legislate to disarm people who are dangerous as a general matter, that this person in this circumstance really is not dangerous. And your test doesn't seem to get to allow us, the way you're talking about it, to assess that. Can you help me with how the means in scrutiny analysis is being folded into Bruin?
Sure. I don't think the means ends analysis is or should be folded into Bruin.
But then how do we keep it from having this very situation where it just boils down to us believing what the modern Congress says about whether or not someone is dangerous?
We would also reject the trust us position.
Okay.
Here's the guardrails. Again, I think I would start with post-ratification history because history is the touchstone of the Bruin inquiry, and the court has repeatedly recognized that when you have a principle from the founding with respect to how to classify which kinds of people present a special danger of misuse, it's not a law trapped in an amber situation. You don't have to accept the founding generation's judgments as to exactly who is or is not dangerous.
Right, but your principle is just the Congress, the founding era identified certain people as dangerous. Your principle has to be specific enough to allow us to adequately or accurately match it. If
Yes.
it's not, then it really doesn't do any work to look at the founding. We just look at today's judgments and we do the kinds of policy analysis that we used to do, which is basically what I hear you saying back and forth with Justice Barrett, right? We're just looking at, like you say, there's a really good reason to do this, and Congress's judgments are grounded in important policy determinations. All that's true, but that's not what the Bruin test is asking us to do.
Respectfully, I'm not saying Congress is doing great work here. I'm saying the tests are in addition to post-ratification history, which tells you the principle is a lot more specific than here's a dangerous category of people, have at it.
So what is the specific thing about habitual drunkards as a category obviously identified at the founding that is parallel to the every other day marijuana user here?
It is that when you habitually use intoxicating substances, you can present special dangers that warrant confinement or imprisonment or other restraints that are greater than what 922G3 is
Yes,
doing.
but you're just defining habitual user differently in those two situations. I mean, you've just defined away the problem. Yes, fine, when you habitually use, but the founding people said when you habitually use, you're falling down drunk in the street. It's like, whatever Justice Gorsuch identified at the beginning, that's what it means to be a habitual user back then, and therefore it presents a category of dangerousness. That's not what we have here. So you can't just redefine it and still say there's a match.
So two problems with that. One is, again, I think if you think that there's not close enough fit between the principle I identified and the judgment of post-ratification history of many states that for a long time have treated unlawful illegal drug users as of a piece, then you have a real problem with Rahimi itself. Because
well, that may be it. I mean, I guess I'm concerned that Bruin and Rahimi are going to be allowing for arbitrary identifications of analogs and producing inconsistent results. You were here in January with respect to the Wolford case when you argued that historical anti-poaching laws were different enough from what Hawaii was doing that it's unconstitutional. Here, you're arguing that historical laws that have nothing to do with guns, very little to do with unlawful users of intoxicants as was going on in the history, are similar enough to cause this law to be unconstitutional. I don't understand how this works anymore in any meaningful way.
Okay, Wolford is a case about a handful of founding-era putative analogs that missed out on what we considered to be the relevant principle with
Yes,
respect-
what you considered. What I'm asking you is how do we know what is the relevant principle here
Again,
versus there?
I think there's a couple of ways of figuring it out. One is with respect to how it's liquidated in post-ratification history. I think that is a far superior approach than what Justice Gorsuch aptly described in his Rahimi concurrence as a sort of free-for-all in which courts of appeals were imposing or having free will to impose their own policy preferences. So I think that is an important check. Two, we're not just saying trust us, Congress. We're saying the process by which you test whether illegal drugs are illegal, are deemed dangerous in whatever it is, the range of things, is something that provides a check for a specific fact-finding that well exceeds the kinds of the determinations that were made with respect to being a habitual drunkard at the framing. It seems like people have an idea of habitual drunkards as like a very defined class. That was not true. Habitual drunkards were within the judgment of a justice of the peace or magistrate with respect to some of their own personal experience. There's no judgment that like a habitual drunkard is specifically dangerous. The Ludwig decision shows that the myriad of cases are not even saying someone was incapable of handling their own affairs.
Thank
so
you.
that is a helpful check.
Thank you.